Welcome back to the Self-Represented Litigant Society Legal Terms series, and this is legal terms that begin with the letter J. We're going to start off with the term joint liability. Now, joint and several liability sometimes can be used, but joint liability is essentially liability that's shared amongst parties. When there is joint liability, or shared liability, that could mean that one party insists that others be sued with him or her. If defendants in a negligence suit, for instance, are jointly and severally liable, all may be sued together or any one may be sued for full satisfaction to the injured party. A judge is a person authorized to determine legal matters in court. A judge can also be referred to as a justice, although a provincially appointed judge or justice should be distinguished from a federally appointed judge or justice. A deputy judge, on the other hand, is a term that's not used across Canada in all the provinces. Primarily in Quebec, Ontario, and the Yukon, you can find deputy judges being people appointed to determine small claims court matters. A supernumerary judge is a judge who has the option to retire at age 65, but instead chooses to sit half of the time of a full judge, up until the age of 75 when mandatory retirement comes into play. A judgment is a judicial decision, or the determination of the court. A court's sentence or decision on the major question in a proceeding. There are a few types of judgments, and I'll get into a few of them right now. First being a default judgment. This is a judgment that's obtained where the defendant fails to defend against the plaintiff or applicant's claim. A summary judgment is, in civil and family law matters, a motion typically that asks the court for a final order without a trial on the basis that there is no genuine issue for trial because the evidence favoring one of the parties is overwhelming. A final order being an order that fully determines an action or a judicial proceeding, so that all that remains to be done is execute the judgment. A temporary or interim order, on the other hand, is something that determines something on a limited basis, and it doesn't fully dispose of the action. Related here is a judgment creditor. In civil cases, it's a person who is owed money under a court judgment or order. The term recipient is used in support enforcement cases. A judgment debtor, on the other hand, in civil cases, is a person who owes money under a court order or judgment. The term payer is used in support enforcement cases in family law. Judicial interim release, or bail as it's referred to, is the release of an accused person between the committal for trial and the trial's completion. The release can be with or without conditions and with or without someone guaranteeing the release or a surety coming on and supporting the person who is accused. We created a separate video series, a 3-part video series, which you can find the link for in the description box below, on bail. And when we talk about bail, it's also good to take a look at Section 11E of the Canadian Charter of Rights and Freedoms, which provides that any person who's charged with an offense has the right not to be denied reasonable bail without just cause. Now, there are 3 reasons which we explore in that video series as reasons why someone would be denied bail. Check out more in the link section below. Judicial notice is the court's recognition of certain facts that can be confirmed by consulting sources of indisputable accuracy, thereby relieving one party of the burden of producing evidence to prove these facts. A court can use this doctrine to admit as proved such facts that are common knowledge to a judicial professional or an average, well-informed citizen. For example, the mail is not delivered on Christmas Day. The sky is blue. Judicial review is a superior court's examination of the conduct of an inferior court, board, committee, or tribunal to ensure the conduct was proper in law. This should be distinguished from an appeal because they're very different. In administrative law, the superior courts will intervene and grant a remedy where a statutory decision maker has acted in an area outside the scope of authority conferred by the empowering statute. What's that mean? It means that if a board or administrative body has acted outside of their jurisdiction, the court will intervene. Jurisdiction is the legal authority of a court to hear a particular matter. It's also the district or limits with which the judgments or orders of the court can be enforced or executed. Jurisdiction may be over subject matter, parties, or location. In addition to having the power to adjudicate, a valid exercise of jurisdiction requires fair notice and the opportunity to be heard. These are part of the fundamental principles of justice. The absence of any essential element of jurisdiction will render the judgment void. See Harris versus the Law Society of Alberta, 1936. Jurisprudence is the science or philosophy of law, the study of the structure of legal systems. Or it can also refer to a term that denotes the collective course of judicial decisions. A jury is a group of people sworn to deliver a verdict after considering evidence delivered to them concerning the issue. In Canada here, the jury system for a criminal matter is typically 12 people. In civil matters, a jury could be less than 12, and that will vary from jurisdiction to jurisdiction. Just cause are reasons that would justify a particular course of action. In the employment context, it refers to reasons which would entitle an employer to dismiss the employee. Take a look at R versus Arthurs, 1967, for more information. Justice is the principle of giving every person his or her due. It's also the other name for a judge. A justice of the peace, on the other hand, is a judicial officer who has the authority to do a variety of things in criminal matters, including issuing warrants and hearing bail applications. They can also sit on provincial offense trials. That concludes this video. Legal terms that begin with the letter J. Please stay tuned for more in this series coming soon. Make sure you subscribe to our channel here and become a free website member of the Self-Represented Litigant Society's website, irepmyself.com. When you become a member, you will become eligible to get this full series in PDF form once all of these video series are complete. So again, once we finish this video series on legal terms, we are going to release a handbook of all of the terms that we covered in this video series in PDF form, printable for you to print them off and use as you wish. Again, if you wish to become a free website member, all it takes is an email address and you creating a password on our website, which is irepmyself.com. Thank you again for watching. If you have comments or questions on the subject matter in this video alone, please don't hesitate to comment below or send us an email.